Hello, you're welcome to PPL518 Alternative Dispute Resolution 2. Remember what I said that in this course we are really looking at arbitration because of how significant and how important it has become over the years. So we're going to be looking at another topic on arbitration that will enrich your knowledge and make you better as you make progress in this course. Remember what we always also say that to get the best out of the course, we must take our notes, we must take part in the activities. We shouldn't be ashamed to ask questions if we have any. So let's not waste time. Let's go and see what interesting thing we are learning today. So this is our eighth lesson, and in this lesson we'll be learning about the recognition and enforcement of arbitral awards. At the end of the lesson, some of the things you'd have learned will be the procedure for applying for recognition and enforcement, the court that has jurisdiction on matters relating to recognition and enforcement, and some of the documentation required in support of an application for recognition and enforcement. First things first, it's important to note that recognition and enforcement may be either or both. So a party who has succeeded in arbitral proceedings may just apply for recognition and hold on without enforcing immediately. And that's what we saw in P&ID. Or you may go ahead and do the two-step procedure of applying for recognition and then applying for enforcement. Or it may go straight and apply for enforcement. So when you hear in this lesson recognition and enforcement, note that it can be either disjunctive or conjunctive. So it commences at the end of arbitral proceedings. I've said that. And the whole point is for the successful party to enjoy the fruit of his award. And it is usually the application is done in any country that is a state party to the New York Convention where the losing party has access. Please note the difference between recognition and enforcement, the court that has jurisdiction for recognition and enforcement, and the court that has jurisdiction for setting aside. For setting aside, only a court in the seat of arbitration. For recognition and enforcement, a court in any country where the losing party has assets, as long as that country is a state party to the New York Convention. Very important. So, of course, if a losing party has assets in the US, like we saw in P&ID, then P&ID went to apply to an American court for recognition and subsequent enforcement, which is still on. So the procedure is stated under Article 4 of the New York Convention. What a petitioner is, the petitioner in this case will be the party who was successful in the arbitral proceedings. So the petitioner applies to the requisite court in whichever country he chooses that is a state party to the New York Convention, and then he attaches to his application supporting documents, three in particular, two fundamental, one maybe not. So first is the original award, which has been duly authenticated, or a certified copy, a duly certified copy of the award. And second is the arbitration agreement, or certified copy of the said agreement. Third, now this is only necessary where the language is different for the country where the party is seeking enforcement. So translation of the arbitral award and the arbitral agreement in the language of the court where the petitioner is seeking enforcement. Okay, so let's quickly um, deal with our activity one. The question I want you to answer is, why may a party to arbitration seek enforcement of an award in another country? Think about it and answer. going on, we said duly authenticated documents, should be submitted. What do we mean by authentication? Authentication is where the whoever is the competent authority in a country certifies that the document is genuine. And how do they do that? They confirm that the signature on the document is genuine and that the copy, if it is a copy that has been submitted, that the copy is identical to the original. Now, if it is an institutional arbitral tribunal that heard the matter, then it's very simple. It's just for the responsible officer in that institution to state, that this is an authentic copy. However, it's important to know that there is no provision in any law or the New York Convention as to who should authenticate an arbitral award or supporting document. So really, what determines who authenticates is the lex fori. That is the rules guiding the country in which the application has been made. So courts in a particular country will accept any form of authentication that they normally accept in that jurisdiction. Then practical points for you to note regarding um, the procedure. First of all, you know that by virtue of the model law and then the amendment of the New York Convention, an arbitration agreement need not be in writing as long as there's proof that an agreement was entered into, proof of intentions by the parties to enter into agreement. So for that purpose also, and where a party is applying for recognition or enforcement, he will not be, strictly speaking, he will not be asked, to prove or to submit a written document if there is nothing in writing. And anyway, even if there's something in writing, the court will still have to consider the validity of the agreement. However, it is not done at the point of arbitration. The question as to whether an arbitration agreement is valid and all that is done at the stage where, the court has to decide whether to enforce or not. And then some jurisdictions, majority of jurisdictions, don't expect the petitioner to submit originals and copies, of the documents at the point at which they are applying, because it's understood that there may be bureaucratic processes that may not make them readily available. However, note that for the Italian courts, they always insist that at the point of submission of the application, all requisite documents required, the arbitration agreement and the award and translation, if necessary, must be submitted with the application. Otherwise, the application will be defeated and the party will have to start a fresh process. Where the courts do not require, submission of originals or copies, then it means that the application can go through. However, originals and or copies can now be submitted later. Another point you have to bear in mind is that enforcement is not automatic. The fact that a party has won, right, an award was given in favor of a party, and the party has filed an application in the jurisdiction where he wants recognition and enforcement, does not mean that it will be granted immediately. The court will have to weigh whether or not there is merit to the application, and in doing this, it's either the court can set aside the award on its own motion, and we talked about the grounds for setting aside on the court's own motion in the previous lesson, or the respondent, that's the party who is dissatisfied with the award, can haven't made an application to set aside the award and succeeded, can challenge the enforcement. And if the respondent challenges haven't succeeded in setting aside the award, the court to whom or to which the application has now been made for enforcement will not enforce the award. However, the fact that courts may not, enforce immediately or automatically. It does not mean that the court to whom an application has been made for enforcement has the right or the authority to begin to comment on minor issues, right? It is not for the court to determine on the merits. It's for the court to enforce. Determination or, um, review of, the grounds upon which to set aside is not done by the court to whom an application for recognition or enforcement has been made. Even if the court does not agree with the procedural, issues that may have arisen in the case, or the way the entire proceedings went, the court cannot refuse enforcement on those grounds. Enforcement is only refused strictly on the 5 grounds provided under Article 5 of the New York Convention. And it is not the court to which, recognition or enforcement an application has been made for that purpose that weighs these points and sets aside an award. It's very important that you bear that in mind. Our last activity, I would like you to answer which authority is charged with the responsibility for authentication under the New York Convention. Let's see if you were paying attention. And with that, we've come to the end of this lesson. You can download the video and watch it over again several times as you wish. And if you have any questions, please feel free to ask. You can put it on the page and then we can discuss it as well. So, well, this is our last lesson, so there's no until our next lesson. But just to thank you for paying attention throughout the course and to wish you all the best in your exams. It's my earnest desire, earnest wish for you that I will not see you next semester when I'm taking this course again, if I am the one taking the course. So thank you very much and take care.